Good afternoon. Welcome back to the Supreme Court of the United Kingdom, where today we are hearing the appeal in Evergreen Marine UK Limited and Nautical Challenge Limited. We are present hearing the submissions of Mr. Rainey, Queen's Counsel, on behalf of the appellant. Mr. Rainey.
My Lord, good afternoon. May I make one correction to what I said before the short adjournment, which was, I think I said that the Eversmart would see the red light of the Alexandra one, which is of course the green light because she's looking at it on the port side. Sorry about that, misspeaking. Secondly, in answer to my Lord Briggs's question about orientation and identification of vessel movement at night, as an admiralty practitioner, I'm more familiar with larger vessels, but larger vessels will have a mast lights astern and a mast light forward, two white lights, which will be at different heights. And those will allow a navigator observing that vessel to observe and detect its orientation, both in themselves, but also in conjunction with the green side light, so that if a vessel is going transverse, as this vessel was, the mast lights will be effectively in a row, whereas if a vessel is turning to approach on a starboard course, the angle between the two mast lights will decrease, and if she's on a straight course, the mast lights will more or less line up, and the red light will then come into sight as well on the other side. In the position in relation to yachts, it may be slightly different at night, because some yachts will only have one mast light. But again, in our submission, proper observation visually will allow the angle between the green light and the mast light and the aspect they bear to each other to ascertain their movement. And one has to bear in mind that almost in all cases now there is some form of radar or ARPA, which I think is what you're referring to, which will enable the position to be very, very closely monitored. So even in the position of a yacht without two vessels without any radar or any ARPA, and with the most simple form of lights, in our submission, proper observation is and always was possible. So that's what I wanted to say about that. My Lord, picking up my proposition 6, I take very shortly, that there's no difference in the application of the crossing rules to vessels crossing outside the channel, that the channel ends in a pilot boarding area, or that the vessel may be crossing right across the channel, or setting to cross right across the channel, in order to take on or put off a pilot. If the crossing rules apply, and that's a question of the interaction of Rule 9 and Rule 15, but if they apply, then they apply with as much vigour in a pilotage boarding area as they apply in any other waters. That's been long established in the cases. I'll be taking to a case in relation to issue 2, the Albano, which cites and applies the Ada, and the Sappho, which were cases where the argument went, well, I was in a pilotage area and she was too, therefore the rules don't apply in the same vigour. Held no, the crossing rules are important, and as important in the pilotage boarding area as in any other area. And that is an advance point dealing with what the Court of Appeal said about pilotage being important. In our submission, it isn't. So those are my propositions on the authorities, and in light of those propositions, I consider thirdly the navigation of Alexandra 1 in this case. And if the court accepts that one's looking really at a continuity principle for entry, or shaping to enter in the sense which I explained that term to Lord Lord Burrows this morning, namely on her entry course and making the course corrections necessary to do it, then the Alexandra 1 was not doing anything of the kind. Firstly, the navigation of the Alexandra 1 was not comparable to a vessel actually entering a narrow channel, or being on a narrow channel course, or proceeding so as to enter a narrow channel, or shaping to enter a narrow channel. Secondly, the navigation of the Alexandra 1 was such as to cross the channel and to put her athwart while manoeuvring to await the boarding of her pilot before being able to enter the channel. She was not approaching the channel so as to proceed along its course, and she deliberately abstained from doing the turn to starboard, which would have enabled her to shape up for the channel course. And therefore, just before we even get on to the details of navigation, there is no rationale for a Kaiser Wilhelm de Grosse or Kuna-Messin approach of continuity with a vessel already in the channel, with a vessel entering the channel or at the entrance to the channel, taking a channel course. This is simply a crossing situation and is comparable to a vessel crossing across the channel, within it, Gulf of Suez, the Ashton, coming across to take up a course within the channel. So if one considers the facts relating to the Alexandra I's navigation, firstly, as I've said, at all relevant times prior to the collision, Alexandra I was not lining herself up to enter the channel and actually held off from making the necessary turn to starboard to do so. And if the court looks at the plot, which is at core bundle 254, we have the plot showing the progress of the Alexandra I in an east-southeasterly broad heading with slight alterations of heading to port and starboard, but mostly to port. And if you go to the blow-up of that, which is at page 249, which picks up the story in blow-up terms, if I can call it that, from 2326, which would be C-16. My Lord Briggs.
I'm sorry, Mr. Innie, I had a connectivity break and I didn't get your second page number, the blow-up page number. 249,
my Lord.
Thank you.
And so what we see from 2328, which is C-14, that the vessel is effectively on an east-southeasterly heading, tracking mostly port, so away from the channel. There is then an orientation right at the very end to starboard, which is very important not to misappreciate. It's been said in the respondent's case at paragraph 33 that she altered her heading to starboard. That is wrong if it is suggested that she was shaping to enter the channel to starboard just before the collision at C-2. The only reason she changes to starboard is because at C-2 she suddenly puts her engines to full astern because the collision is imminent. So at all times before that, she was drifting across the channel, and I'll take the court in a moment to the passages in Mr. Justice Tier's judgment which make that plain. Her heading was just over 101 degrees, where the channel axis is 315 to 135 degrees, so she was in no sense lined up for the channel or lining up the channel. But critically, no starboard helm order was given. A starboard helm order was given at C-22, but that was countermanded subsequently by a midships order. And one of the positions the judge had to consider was whether she actually decided ever to turn to starboard or not. The judge held she didn't, and the reason for that is, as the judge found, is that she had poor oral lookout, which meant that she had misunderstood the port control communication, which said that a tug of the Zakia Bravo was passing from west to east. She wrongly, not listening to the message correctly, believed that to be a conversation with Eversmart. The result was that she was navigating herself so as not to enter the channel on her side of it, but to allow the Eversmart, as she thought, to pass astern of her, to take on her pilot in due course. And so for that reason, the Alexandra I navigates slowly across the channel entrance, not into, nor even shaping, in the proper sense of that word, to turn into it. And if I can ask the court to turn to Mr. Justice Tier's judgment, and to pick it up, please, in the core bundle at CV, page 197. The judge in paragraph 19, describing the position at 2337, C-5, the Alexandra speed was 2.1 knots. And this time she's going dead slow ahead. So there's an engine order on, and this vessel has way on, caused by the engine order which has been given to her. And she was making good a course of 106 degrees, so a course which is antithetical to her lining up to the, or being on any form of immediate lining up for entry to the channel. Although her heading was again falling off to port and was now 92 degrees, so she's getting even further away from heading up for the channel. The audio record has the master says it's time for us to make a turn. He must have had in mind a turn to starboard for the channel. So pause there. He hasn't started turning to starboard for the channel yet. He's coming up to the time when if he's going to do it, he's got to do it. The plots provided by the parties showing the progress of Alexandra 1 do indeed show her at C-5 as approaching the point at which one would expect her to turn to starboard so as to line up on the starboard side of the approaches to the channel. Pause there. In the Canberra Star, the City of Lions had already long lined up, and in the Kulamesin, the Yauhai had already long lined up. But the course made good and heading changes do not suggest there was any starboard helm action. At 23:38 or C-4, when her course was 102 degrees and heading 90 degrees, so again, still away from the channel, the engines of the Alexandra 1 were put to slow ahead. So then she has engine orders, which are giving her way. The audio record again suggests the master was concerned it was about time to turn into the channel. There's an inexplicable conversation about a grasshopper. And then if you just jump down the middle of the paragraph, the audio record does not contain a starboard helm order. None of those on the bridge of Alexandra 1 refer in their statements to a starboard helm order. The heading of Alexandra 1 did not appreciably change, and therefore do not consider there was a helm order. The master did, however, consider that it was time to turn to starboard so as to turn the channel. But the effect of not turning to starboard was that Alexandra 1 continued heading so as to cross the approaches of the channel. And if one goes on to paragraph 57, which is at page 204, I picked this up simply because this is the reference in paragraph 33, paragraph 33 of the respondent's case about the heading to starboard change. Second sentence, for reasons I have given, I do not consider...
Sorry, paragraph number, Mr. Rainey, sorry.
Paragraph 57, I apologise.
Thank you very much.
Third sentence, for the reasons I've given, I do not consider it probable there was any starboard helm order before the collision. The change of heading to starboard is more likely to have been the result of the engines, Alexandra 1 being put full astern at C2. But the circumstance before that, with Alexandra had been proceeding very slowly towards the channel entrance, whilst waiting to embark her pilot in order to proceed down the channel. So there never was a turn to starboard, and that was that. Paragraph 82, which is at page 211, and this touches on my Lord Briggs's point about what you can see by the orientation. Thus, the master's visual lookout was seriously defective. Masthead lights are visible at a minimum distance of 6 miles, and side lights at a minimum distance of 3 miles. Had the master kept a good visual lookout, he would see not only the green side light of Alexandra 1, but also the orientation of the masthead lights, which would have indicated to him from about C-4 that Alexandra 1 was not set to pass Eversmart port to port, but was heading across his bows, or as he told his owners, transverse. Just pause there, he then refers to the radar target. That means that the vessel is coming down in an east-southeasterly broad heading towards the Eversmart. And what the Eversmart sees are the masthead lights and the green light in such an orientation that shows that she is going to pass transverse across her bows in a crossing situation. What they might have seen, had the master decided at C-4 to turn to starboard, with the change of orientation to show that she was in fact turning to starboard. She never did. And then paragraph 103, at page 217, under the heading failure to navigate in such a manner that when she reached the channel she would be on the starboard side in accordance with the narrow channel rule. This is founded on the judge's rejection of the application of the crossing rule. Alexandra 1 decided to head across the approach into the channel rather than at C-5 or C-4 turn to starboard so as to pass Eversmart port to port in the approaches to the channel. Seems to me that but for the master's poor oral lookout, he would have altered course to starboard so as to approach the channel in such a manner that when he reached it, Alexandra 1 would be on the starboard side of the channel in accordance with the narrow channel rule. Instead, at C-3, Alexandra 1 was heading about 90 degrees so as to cross the approaches to the channel, and at collision, Alexandra 1 was crossing the approaches to the channel on a heading of 101 degrees with her bows on the centre line of the channel as extended from number 1 buoys. From such a position, it would have been difficult to reach the channel at the number 1 buoys on the starboard side of it. And then at the bottom, a penultimate, anti-penultimate sentence, such a snaking manoeuvre is not the sort of manoeuvre which would be expected of a vessel approaching a narrow channel. So in terms of observable navigation and what she was actually doing objectively, this was not an entry course, nor was it a shaping to enter course, nor was it a course comparable to the facts in the two cases we just considered before lunch. My Lord Hamlin.
I'd say, Mr. Rainey, that from the judge's finding, the course she was on until C4 or 5 was consistent with a course that would lead to an approach into the channel.
Yes,
my Lord. Only at that stage the judge says you would expect to occur. So until then, it's consistent with that eventuality.
Yes, but that's the importance of observation and the application of the crossing rule, because before then she's crossing. You don't actually know what she's going to do. At C minus 5 or C minus 4, if she suddenly turns to starboard, you realise there is no crossing situation because the vessel is not going to cross. She's now going to come down on your port side. But you don't actually know until she does or doesn't do what she should do, what she's going to do. That is, so in our submission, there isn't a sort of, she's crossing and she always crosses. Cases like Lord Una establish that the crossing situation applies, but then you may enter into a new phase when it no longer applies because the vessel is no longer going to cross. And so it's an iterative process where you follow the navigation as it goes along, and things change. So what looks like a crossing situation with a risk of collision suddenly isn't one because of the manoeuvre which is taken. Or an approach to a channel which looks as though she might be going to shape up to enter suddenly ceases to be one because she doesn't turn to starboard and she goes across and keeps on going across, which is what this vessel did.
Just a moment, Mr. Rainey, I think there may be a problem with the assessors.
Oh, sorry, but I didn't notice.
No, don't worry, you're fully occupied in making your submissions. I think we'll adjourn the hearing. The hearing's adjourned for the moment. Mr. Rainey.
And so, just continuing my answer to my Lord Hamlin, the course of navigation followed by the Eversmart up to C minus 5, C minus 4 is consistent with two things. She could be going to make a starboard turn. She could be going to go across because she's not in a position yet to make a starboard turn. C minus 5, C minus 4, you then say, well, she's leaving it too late to do it now, so she's not making a starboard turn, and so she is going to cross. That is the way in our submission it works. And that is why it's important to have constant observation. And that brings me on to a point before I leave the navigation of the Alexander.
Before you move on from that, does it follow from that, Mr. Rainey, that until C minus 4, C minus 5, an observer would not know which rules would apply?
No, an observer knows that the crossing rule applies because she's in a crossing situation. Looking at her course, and that raises issue too. Looking at her course, one, is she set to cross? Yes. Two, if nothing changes, will there be a risk of collision or a close quarter situation? Yes. Rule 15 is engaged. Rule 15 continues to be engaged until Rule 15 ceases to be engaged. C minus 5, the vessel turns sharply to starboard to put herself down to her side of the channel. Crossing rule ceases to apply. Rule 9A now applies.
Thank you.
If the crossing rules applied, at what stage would the vessels have to take action, or the giveaway vessel have to take action under them in this situation?
In our situation, yeah. Well, where the master of the Alexandra 1 knows, as the judge puts it, that she decides to head across the approach to the channel and appreciates that there is a crossing situation developing, then the giveaway vessel must take steps to keep out of the way early under Rule 16.
That's still at C4 or C5, is it?
Well, that would be far too late, because at that stage, he's on a cross. Long before that, C-20, he's on a crossing course. Now, unless he decides to do something about it, for example, he could address that crossing course by saying, I am going to turn to starboard now to line up much more dramatically with the channel. That would remove from me being on a crossing course, take me out of Rule 15 altogether, and put me in Rule 9A. What he can't do is, as it were, to keep going on a crossing course and leave it that late, because he is a give-way vessel at that time. He can stop himself being a give-way vessel at C-20 by doing what he might otherwise do, but he doesn't. And in those circumstances, from C-20, we would say, he needs to take action. He can take action in a whole host of ways. For example, by turning to starboard to shape a line into the channel. Does that exist? My Lord Briggs.
Yes. Does not Rule 16 help at this point? Because if you're the give-way vessel, you're meant to take early and substantial action to keep well clear. And I think somewhere else in the rules it says action which is clear enough to be seen to show the other vessel what you're doing.
Absolutely, my Lord, which is why I said in answer to my Lord Hamlin, you need to take early action.
Yeah.
A crossing situation arises simply because you're on a crossing course which causes the risk of collision. As soon as that happens, the vessels come under two sets of obligations. The vessel on the starboard side stands on, keeps doing what she's doing, so the give-way vessel knows what she has to do. The give-way vessel then can't just say, well, if I continue on this course, there will be a risk of collision, but I'll leave it until a bit later. He has to take early and substantial action. And he can do it in a whole host of ways. He can say, well, I don't quite know whether the pilot's ready for me yet. I'll slow right down. They can't go any slower. Or he could anchor, or he could decide to go to port, or he could decide to go to starboard and take up a line to the channel, which instantly will signify to the stand-on vessel that she's no longer in a crossing situation. To the stand-on vessel, she's no longer with the vessel ahead, and then the crossing situation evaporates, as it was put in the Orduna. The crossing phase comes to an end, and you enter a new phase. But the logic is absolutely right. And the difficulty, both with issue 1 and issue 2, is that we have a vessel which is being navigated, dead slow ahead, later slow ahead, on a broad east-southeasterly course, with variations in heading caused by the fact she's going very slow, and there are current matters. In those circumstances, can she simply let herself go on and say, you must get out of my way? And our submission, it's completely unworkable. And both in issue 2, because it highlights the questions that have been put to me, highlight the dilemma in issue 2. The vessel is underway with way on, 1.5, 2 knots. Engine orders being given, helm orders being given, or not very many. She's on a broad course. That broad course is going to take you into a crossing. That crossing has a risk of collision. We know it had a risk of collision because it had one, and the judge found it gave rise to a risk of collision. But nevertheless, the crossing rules don't apply. It's a very odd situation. And you get out of it on issue 1 by saying, well, I know I'm drifting across the channel, but in the vicinity of the channel, it doesn't really matter because the crossing rule doesn't apply. In our submission, that adds enormous uncertainty for professional and amateur mariners as to this vessel which is coming across very slowly, so what? On a broad heading, but with slight variations of course, so what? And is obviously crossing with the risk of collision, but doesn't have to do anything about it. So,
could I perhaps ask a very similar question, I think, to Lord Hamblin's, but from a slightly different perspective? If I'm the incoming vessel and I am anxious to ensure that I comply with the narrow channel rule, how early on would I need to be shaping up to enter in order to comply with the narrow channel rule?
Well, that would depend upon the nature of the narrow channel. I mean, here, as soon as the vessel realised at C-20, say, the Alexandra One, that the crossing situation was being created by what she was doing, and she could have started to turn much more sharply to starboard and slow down so that she was lined up ready for the starboard side of the channel and waiting for the pilot, as it were, pointing in the right direction for down channel entry, waiting for the pilot and controlling her position in that way. In one sense, it comes back to, so that's my answer to that question, but your Lordship's question raises another one, which is the question raised by my Lady Arden, which is if she couldn't go into the channel without a pilot, then she might not be able to line up at all until she had a pilot on board. So that's the navigation aspect. Can I just pick up, before I leave the navigation aspect, this pilot area boarding point? I will show the court, when I'm dealing with issue 2, the decision of the Privy Council in the Albano, which establishes that the crossing rules apply as much in a pilot boarding area or around pilotage as anywhere else, and indeed probably need to apply there because vessels are racing for pilots. So that's my proposition 6. But the Court of Appeal, in paragraph 60, perhaps I can ask the court to turn that up, which is at page 163 of the bundle. Introduced a new element, and this is a new element in the Court of Appeal's reasoning. This was not an element in the judge's reasoning on issue 1. The judge found it relevant in relation to issue 2. That's a different question. In relation to issue 1, the Court of Appeal introduced this element. Paragraph 59. This case centrally concerns a narrow channel with its entrance and exit in the pilot boarding area, not the open sea. Well, that happens a lot. At all material times, Alexandra I was already in the pilot boarding area. She was there to state the obvious, with a view to embarking a pilot and entering the narrow channel. The greatest respect, so what? That was the only reasonable inference to be drawn by Eversmart as to Alexandra I's future course. Now, that is a very odd statement. One, it's a complete misunderstanding of the Peking, as it's been applied in later cases, including the Alcoa Rambler, which I'll take you to in a moment. But what is it that it is obvious that the Alexandra I is doing? That at some time in the future, the Alexandra I would take on a pilot. That at some time in the future, having done so, she would then seek to enter the channel. And thirdly, at some time in the future, would do so by whatever navigational manoeuvre was necessary to line up. She would do so by whatever line up as she then stood. I mean, if she was crossing, and then she took up the pilot on the wrong side, then she'd have to go round again and come back. But in our submission to say, oh, well, she's going to pick up a pilot, therefore I can infer what she's going to do, is wrong. Because for two reasons. One, it doesn't tell you what she's actually going to do, because only observation will tell you that. And two, as this case shows, that inference would have been entirely wrong, because she wasn't intending to line up and go in. She was intending to wait, take a pilot, and keep drifting across until she did. And the difficulty with that approach is that it is completely contrary to how the Peking has been understood and applied. I can take the court to the Alcoa Rambler, very short passage, in the core bundle at page 323, I hope. (323) or 324. And we'll come back to the Alcoa Rambler in another context in issue 2. For these purposes, the relevant passage in the opinion of the board given by Lord Wright is at the bottom of page 323. And it starts about 15 lines up, and it says this. The question whether the two vessels were crossing vessels in the article thus depended on the purpose of Norafjord's movement, so far as that purpose could be inferred by the master from what he saw. The issue always depends on the reasonable inference to be drawn by the ship, which has the other on her starboard side, as to the latter vessel's future course, deduced from observation of her movement, making due allowance for the nature of the locality where she is at that moment. So she's in a pilotage area, you factor that in, but you still watch what she's doing and watch what course she's on and what she is doing and what she isn't doing. And what she isn't doing is turning to starboard, and what she isn't doing is taking the pilot on at that moment. So it is stated in the Albano in a quotation made by Sir Gorrell Barnes from Lawson Hellier in the Peking. So the reasonable inference, and it's all different because it's in the pilotage boarding area point that was introduced by the Court of Appeal, is the greatest respect wrong in principle. You can't draw an inference about how this vessel is going to be navigated from the fact she's in a pilotage area and will be intending to pick up a pilot. You don't know where she's going. Based on that, you have to watch her course and see what she's doing. And then, based on what you see, on the observations of her movements, that is the only basis on which you can do inferences as to what she's just about to do next. So, my Lord, that concerns the navigation of the Alexandra I. And in our submission, it's about as different from the facts in the Canberra Star and the Kula Messin, or the Willem de Groosa, or the example given in the Treherbert, as it's possible to be. This is not an entry course, nor it's a shaping course. And therefore, when the judge and the Court of Appeal say the facts are indistinguishable from the facts in those cases, in our submission, that is simply wrong. This brings me on to my last section on issue 1, which is the reasoning of the courts below. And I think in the light of my submissions, I can now take this quite shortly. Mr. Justice Tier based himself on 2 matters: the authority of the Canberra Star and the Kula Messin, and his view that the rules would require different actions and there would be inconsistency. Can I take both of those aspects briefly? First of all, Mr. Justice Tier's view of the cases. If the court turns in his judgment to paragraph 44, which is at page 201, or 202, the judge starts by setting out paragraph 43. He says that after referring to the Empire Brent, he says those are cases of vessels going in and going up and going down, both in the channel. He then refers to the Canberra Star, and he says this at 45: the circumstances of that case are arguably comparable. I'll note the fact that he's quite tentative at that stage, but in our submission he's already wrong. Comparable to the circumstances of the present case, which concerns a vessel navigating within a channel and another vessel approaching the entrance of the channel with a view to embarking a pilot and then entering the channel. There is the critical distinction with the Canberra Star and the facts of our case. The statement of principle by Mr. Justice Houston is therefore some support for the case of Alexandra I. Just pause there. If you turn back to what the case of the Alexandra I was, at page 200, in the middle of paragraph 39, it is that Miss Selvaratnam QC submitted that authority establishes that the crossing rules have very limited, if any, application to questions of navigation in and around a narrow channel. Pause there. That is a statement of principle which is being sought to be derived from these cases. That's the vicinity point. And in some way, when you come within the penumbra of the mouth of a narrow channel, Rule 15 evaporates. And in our submission, one would struggle to get anything like that out of any of the cases. And in particular, do not apply to a vessel in a narrow channel and a vessel navigating towards that channel in preparation for entering it. Well, that's where the cases go beyond entry and entry courses and cover preparation for entering when you're not yet in a position to enter. And in our submission, they don't. But interestingly, the judge at paragraph 40 on the same page puts it in our submission in completely the wrong way, with the greatest respect. I consider first the question whether the crossing rules apply in the vicinity of a narrow channel. So that's a vicinity test. And no case has suggested they don't apply in the vicinity of the narrow channel. On the contrary, they apply in the narrow channel, if a vessel is going across it, even to join the other side of it. So why shouldn't they apply in the vicinity of the narrow channel? So that's what he says about the Canberra Star. He then refers to the Kula Messin, paragraph going back to page 202, and he says the circumstances of that case appear to be similar, although not, of course, identical. And if you turn over to the top of page 203, he says the two vessels were crossing. The difference between Kula Messin and the present case was that YH was not planning to embark a pilot before entering the channel, whereas Alexandra I was. But that's not the difference. The difference, with respect, is that the Yao Hai was on her course at 13.5 knots with minor course corrections and was on her starboard entry course. And then he says this: the statements of principle that the crossing support the case of Alexandra I, that the crossing rule did not apply in this case. Well, that would require this court to identify what the statements of principle are, and then to say that it endorses the result. In our submission, they're not what they are said to be, and they don't endorse the result. That's the first point, the judge dealing with authority. The second point is the judge dealing with inconsistency, and we can pick that up at paragraph 52 on the same page, 203. He deals with, he cites Lord Clarke in Coulomesson, which I've already dealt with. He says, paragraph 52, similar point made by Mr. Justice Wilmer in the Empire Brent, where the crossing rule did not apply to two vessels navigating a narrow channel because the requirements under the rules are different. And we've already analysed why that is so for two vessels within the channel, both having to keep to their starboard side. You don't need the crossing rules. And then this, similarly, where one vessel is within a narrow channel and has a vessel on her port bow and a crossing course outside the channel, but proceeding towards it in preparation for entering it, well, how does the vessel observing it know it's preparing to enter until it is actually going to start to enter? The vessel in the narrow channel cannot be under a duty pursuant to the crossing rules to maintain her course and speed, and at the same time under a duty pursuant to the narrow channel rule to keep to the starboard side, since the two duties may, depending upon the circumstances, require different action. And one asks, why is that so? What is the inconsistency? What different action? Go back to the two situations which I opened my address this morning with, situation 1 and situation 2. Take situation 1, where a vessel is within the channel, going from moorings on one side across to a wharf on the other. Alter that to the facts of the Ashton. Vessel coming into the channel from Grimsby to go across the channel to get into it on the other side. No suggestion in any of the cases that the principles are inconsistent. You have to comply with both. You've got to get over to your starboard side, if you're the stand-on vessel, and you've got to maintain your course and speed. So in our submission, the judge hasn't factored in what happens within a channel and hasn't addressed, just having cited Mr. Justice Wilmer in the Empire Brent, how Mr. Justice Wilmer contemplated in cases like the Ashton and others, that the two rules apply in a crossing situation within the channel. If they apply without any difficulty within the channel, why don't they apply outside the channel? There's no reason. And nothing is really identified, either by the judge or by the Court of Appeal or by the appellants in their case, as to what this conflict is. And the reason for that is that the judge, as the Court of Appeal, has omitted to bear in mind that the crossing rule permits course, i.e. the duty on the stand-on vessel, that she should keep her course and speed, permits course and speed variations incidental to the navigation which she's actually on. So to take an example, a vessel is coming up a channel. She has a wind right across the channel. She's high-sided. She's continually pushed from the starboard side to the middle of the channel, even sometimes over the middle of the channel line. She continually has to starboard to get herself over to the right side of the channel. So she's effectively doing this, coming up the channel to the channel mouth. The two duties apply equally, and her stand-on obligation to maintain her course and speed accommodates, on the cases, the fact that she may be, as it were, porting and starboarding as she's coming up the channel. That is clear from cases such as the Alcoa Rambler, but also from the Roanoke, which I can take you to now, with a very, very striking example of it in the Taunton. The Roanoke is in the authorities bundle. Now, I think this page number may have gone wrong because of inserts which have been put in, but I'm going to be bold and say 420. But if there is a difficulty, can I ask the court to click on the index and the electronic page for that? I think what's happened is that inserts have been put in.
It is.
It is 420.
420.
Well, better not count my luck too much. So if we go to 420, sorry, Mo. So this is another good example of why the crossing rules apply in pilotage areas. Two vessels were approaching a pilot vessel to take on the pilot. And it was argued that the special rules apply because it's pilotage, and the court rejected that. And if I can ask you to turn on, please, to page 426. The issue which arose in this appeal was that a vessel was proceeding to the pilotage area to pick up a pilot, and she was the stand-on vessel. And rather than maintain her course and speed, she slowed down to pick up the pilot. The pilot was in his launch waiting to be picked up. Mr. Justice Buckner at first instance said, aha, you are in breach of the stand-on rule because you didn't keep your speed and you shouldn't have slowed down. And the Court of Appeal said, no, there must be some flexibility in the obligation of the stand-on vessel to take account of what is incidental to the navigation which he's actually on. So here, the navigation which we would actually be on would be navigating up a channel, needing to keep to the starboard side with any course corrections that were necessary to do so, and to maintain our course and speed. And so the case deals with that. And if I can ask you to turn to page 428. The case of the Ada, the Sappho, and the case of the Albano, I said I'd come back to those, both decided, as Mr. Justice Butler did in this case, that the crossing rules apply when two vessels are approaching a place where they propose to take up a pilot. So that shows that the Court of Appeal was wrong to say that the pilotage boarding areas are different, close quotes. And in my judgment, to hold that a vessel was not entitled to reduce her speed in order to take a pilot on board when that manoeuvre was perfectly visible to the ship whose duty it was to keep out of the way, would impose a most dangerous and serious risk upon vessels navigating in the ordinary course. In my judgment, course and speed in Article 21 mean course and speed in following the nautical manoeuvre in which, to the knowledge of the other vessel, the vessel is at the time engaged. Pause there. What is the nautical manoeuvre in which we were engaged as the stand-on vessel, which any stand-on vessel is going to be engaged in the particular situation we're considering here, namely vessel coming to the end of a channel, keeping to the starboard side or not keeping to the starboard side, Rule 9A applying, Rule 17A1 applying to her. It is not difficult to give many instances which support this view. The course certainly does not mean the actual compass direction of the heading of the vessel at the time the other is sighted, see the velocity. A vessel bound to keep her course and speed may be obliged to reduce her speed to avoid some danger of navigation, and the question must be in each such case, is the manoeuvre in which the vessel is engaged an ordinary and proper manoeuvre in the course of navigation, which will require an alteration of course and speed, or the other vessel to be aware of the manoeuvre which is being attempted to be carried out. So if you have a vessel which is coming up the channel, trying to keep on her starboard side, the vessel watching her will think she's a vessel coming up to the exit that will be exiting either on the starboard side or as close to the starboard side as she should get there. Now, I, as a giveaway vessel, can see that, so I've got no difficulty in reacting to what she's doing. She, as a vessel coming up, will have to try to comply with both rules, and there's no difficulty about that. Vessels that don't are found in breach of both rules, as the King Stephen was in the Ashton. And the judgment of Lord Justice Farwell said this at page 431. That so to hold, bottom of the first paragraph, would be to shift the duty of keeping out of the way from the giving way vessel to the other, and would make Article 21 read, it's Article 17, as if the latter vessel were bound to keep her course and speed so as to keep out of the way of the giving way vessel, instead of so as to enable the giving way vessel to keep out of the way, which is, in my opinion, the true construction. So in our submission, Mr. Justice Tier was unable to postulate what the actual conflict was, or how Rule 9A and Rule 17A1 would impose conflicting obligations on the stand-on vessel. And there aren't any. The Taunton, which is in, I think rather than, given the time, and given the fact that the Taunton is going to be difficult to find in the bundle, Taunton is in the second authorities bundle, tab 33. The Taunton was a case where the stand-on vessel was effectively crabbing. She was a small ketch which was caught by a very strong tide across her course. She was continually being set to port. She was continually battling to try to get back to the line she needed for Cardiff docks. And Lord Justice Grutton, again in a very characteristic passage, so that anybody reading Rule 17, maintain her course and speed, would think that she wasn't maintaining her course and speed, but she was, because if you look at what she's trying to do and what she is doing, even if she's doing that, she has a course and speed which she is maintaining, given the vagaries of what she's being subjected to. That complies with Rule 17A1. So that's the judgment of Mr. Justice Tier. The judgment of the Court of Appeal rested on the same matters. Can I deal first of all with how they dealt with, so if we go to paragraph 60 in the Court of Appeal's judgment at page 163, as we've seen, paragraph 60 to 61, they deal with the pilotage point. I've dealt with that. Then they deal with the inconsistent obligations point. You see that the Court of Appeal in paragraph 63 refer to the Roanoke and the Taunton and the Alcoa Rambler, what I've just been dealing with now. And then they say this, at 63.2, even aligned with the impact of these authorities, I'm wholly unable to accept Mr. Jacobs' submission. There was no risk of any such inconsistency here by reason of the precise manoeuvres undertaken by Eversmart. It is the situation as a whole that falls to be considered. It's, to my mind, unrealistic to suggest there was no risk of the narrow channel rule and the crossing rules potentially requiring different actions at the same time. With greatest respect, that's not understood, and no example of it is given. It must be unlikely that a proper application of the collision regulations would place a seaman in an invidious position of this nature. If the seaman being spoken of there is the seaman on the stand-on vessel, no case has ever suggested that when they've applied both rules at the same time, and again, no example is given. That a particular course correction, for example, a one-off obvious and decisive manoeuvre to regain the starboard side of the channel, might not be inconsistent with both rules, seems to me to be neither here nor there. Take the example of a vessel which is being caught by windage and is constantly porting and constantly starboarding. It doesn't need to be one decision only. And then this, in any event where both rules to be applicable, the scope for confusion for the putative giveaway vessel faced with a putative stand-on vessel lingering to port of mid-channel is considerable. That too is not understood. The giveaway vessel, that's precisely the point if the case is like the Taunton. The giveaway vessel knows very well that a vessel is coming out of that channel and should be or is trying to come out on the starboard side. For some reason isn't. The giveaway vessel can appreciate, as this giveaway vessel could have appreciated, that the crossing course was going to be set up and she could easily take measures to avoid it. That's all she needs to be able to appreciate. And in those circumstances, the decision of the Court of Appeal that there's an inconsistency is similarly wrong. In relation to the authorities considered, the Court of Appeal effectively didn't really identify what the principle was on the Canberra Star. And in relation to Cooler Messing, said the facts were indistinguishable. With great respect, they're very distinguishable. So for those reasons, we submit that the appeal should be allowed on issue 1, and the crossing rule is not to be disapplied to any vessel preparing to enter a channel or in the vicinity of the channel entrance. And the decision in our submission is productive of uncertainty and danger. The settled extension on the continuity principle in very limited circumstances of Rule 9A to vessels actually entering or actually on their shaping to enter courses is explicable and was well explained by the trial judge in Cooler-Missing and as endorsed by Lord Clark in Cooler-Missing. There's no application to a vessel which is merely preparing to enter and which is drifting across the channel mouth, just as it has no application to a vessel like the trawler from Grimsby coming out, crossing the mouth, preparatory to going in on the right side. And one only has to pose situations which could arise east-west or a west-east example. Assume this vessel at C-3 or C-10 had received orders from her time charterers not to berth. Do not take your pilot. There are problems with receivers and the cargo. Do not berth. The vessel then steams across the channel. She is still, she will be berthing at some stage, preparing to enter, but there's now a delay in entering for some reason. What happens then? Are the rules disapplied because we're in the vicinity of the channel? How close to preparing to enter and entering you have to be? It makes no sense. What is obviously a crossing situation, one of the most dangerous situations there is, where Lord Wright in the Alcoa Rambler said wherever possible you should be applying the crossing rule because they achieve safe navigation, has been discarded in favour of a very uncertain position. And when one considers what the Court of Appeal did with the east-west case, a very uncertain position and a very unsatisfactory one. So for those reasons, issue 1 in our submission, the appeal should be allowed. Issue 2, unless I can help the court further on issue 1.
Thank you, Mr. Rainey.
Thank you, my lord. Issue 2 raises a question of the general scope of the crossing rule. So now we're away from the narrow channel and we're considering any crossing situation anywhere. And the issue is this: does the putative giveaway vessel have to be on a steady, or Mr. Justice Tier, endorsed by the Court of Appeal, put it, a sufficiently defined course in order for Rule 15 to be engaged? And issue 2 arises in a very stark form, which is why it causes considerable concern. Alexandra 1, as we've seen from my analysis of the facts set out by the judge, was on a varying course, but was proceeding and was being navigated under power deliberately on a definite broad heading and a definite broad direction for a purpose: east-southeast. Indeed, in the Respondent's Preliminary Act, or Collision Statement of Case as they're now called, which has that slightly sacrosanct quality of counting as admissions against the person who pleads it, I don't take a point on that. The respondents themselves said, in answer to the questions, I'll take you to that in a moment, what were you doing? We were on a broad east-southeasterly course, slowly proceeding to pick up a pilot. That's where she's going. That's what she's doing. The result of that navigation of the Alexandra 1 is to set her to cross the path of the Eversmart. There's no doubt that a crossing situation is being created. The Eversmart is coming up the channel towards her and on her starboard side. There's very little room for manoeuvre for the Eversmart because of the channel. By reason of the direction and the heading then being followed by the Alexandra 1, she was, in the judge's words, paragraph 82, set to pass across the bows of Eversmart and transverse to her. That crossing of Alexandra 1 and Eversmart plainly involved the risk of collision and of a close quarters situation. And that was so, as the judge found, rejecting one of the respondents' points, irrespective of how the Eversmart went over to starboard or not. There was still going to be a risk of collision caused by the way in which the channel was oriented up to where Alexandra 1 was navigating. The compass bearing of the approaching vessel did not change materially at any time. So there was a risk of collision for the purposes of Rule 7D1, which I'll take the court to in a moment. So we have a crossing situation with a risk of collision caused by the way in which a vessel is being navigated at 1.5 to 2 knots, with helm orders being given or not given, and engine orders being given as appropriate by the vessel to do what it wants to do. And in that situation it is held that as a matter of law, that crossing with that risk of collision is not within Rule 15. So the Alexandra 1 does not have to give way, and so presumably in a crossing situation which is similar, just as Lord Justice Farwell deprecated, the vessel which is on her starboard side, which has her on her port side, has to give way to her. So she can navigate effectively as she likes, but the stand-on vessel, putative stand-on vessel, is now a give-way vessel. And in our submission, that is simply wrong as a matter of principle and has not been subjected to the right degree of analysis. The point, it's fair to say, to the Admiralty judge came up very late in oral argument, so the judge wasn't really addressed on the authorities and on the principles. The Court of Appeal were, but they endorsed the decision of the Admiralty judge in our submission again, without really appreciating what the correct analysis is. So I want to deal with this issue in 5 sections. First, I want to consider the crossing rules and when they are engaged. What is crossing? Why does it matter? Secondly, I want to consider the requirement settled in the cases that the stand-on vessel must be on a steady, sufficiently defined course, and the reason why the stand-on vessel has to be, and why that requirement does not apply to the give-way vessel. It seems to be so, well, you've both got to be on that. There's no reason for that in our submission. Indeed, it's contrary to basic principle. Third, I'll look at the relevant authorities, including the extract from Captain Cockcroft and Captain Lemare's book, which my Lord Briggs referred to this morning. and why that's important and why it fits in with two decisions, the Broomfield and the Devotion 2, which is not mentioned in our case, which is in the supplementary authorities. And fifth, I'll then consider the reasoning of the judge and the Court of Appeal, which this court should not follow. So firstly, let us deal with Rule 15, and I can be short with this because we looked at Rule 15 this morning. As we've already seen, Rule 15 it applies in the sense that it defines the circumstance in which a crossing situation is deemed to exist, engaging Rules 16 and 17. And as we've already seen, it will be taken to exist wherever the vessels, open quotes, are crossing, close quotes, and where that crossing is such as, open quotes, so as to involve a risk of collision, close quotes. Nothing more is required. I'll take each element separately, but before I do, and I ask the court to note that Rule 15, therefore, does not itself use the word course as a matter of language. It simply uses the term crossing, which has a clear and straightforward meaning. My path will cross your path with the risk of collision. Therefore, we're going to be either in close quarters or we will strike if nothing changes. The rule does not say are on crossing courses, nor does it say or are on courses which are set to cross. And therefore, it can be contrasted with certain rules which do define the situation in terms of courses. Take, for example, Rule 14a, which deals with the head-on situation and which applies when two vessels are meeting, I quote, are meeting on reciprocal or nearly reciprocal courses. And therefore, the requirement of a course to be followed by the give-way vessel with a very particular definition that the course can't just be a broad course, it has to be a sufficiently defined course, will not be found in Rule 15 and must be a necessarily implicit requirement. And then the court has to ask where and why is it necessarily implicit. If we take the two elements then of Rule 15, and first of all, crossing, as I've said, what does it mean? As a matter of language, where one vessel will, if she continues to proceed as she is proceeding, cross the path being followed by another vessel which is approaching her on her starboard side. All it requires is that if matters continue as they are, the paths will intersect and converge. And may I take the court in that connection to the Albano, which is the pilotage case, and which involves a vessel going very, very slowly to become a pilot and being held to be in a crossing situation. It's the authorities bundle 293. Now, the facts of the matter were as follows. This was an appeal to the Privy Council from the Supreme Court of Canada. The facts were these. The Albano was on a course west-southwest for a pilot station. The Parisian was on a course to the same pilot station, north-northwest. The Parisian, therefore, had the Albano approaching on her starboard side, and it was argued by the Parisian that the Parisian was not a give-way vessel because crossing rules couldn't apply because she was stationary, and also because she was picking up a pilot. And when you're talking about pilotage, things are different. Court of Appeals approach. It's important to have in mind that the Parisian, if you turn please to page 297, had approached the pilot station at speed, 14, 15 knots, and then had taken all way off. So the court will see at the middle of page 297, the engines of the Parisian at 457 by her time were set at half speed, at 458 at slow, and 459 then stopped, as the vessel was gradually approaching the spot at which it was to take her pilot. Her course by this time had been altered to north by west. While she was thus running off speed, the rowboat from the pilot cutter puts off from the pilot cutter and then doesn't get there in time because the collision happens. And it was argued that the vessel was stationary. So this is the giveaway vessel. Page 198, the Privy Council dismissed that, middle of the page. At the trial, there was a contest as to whether the Parisian had any way upon her and become stationary in the water, time when the Albano was approaching close to her. The conclusion to be drawn And the evidence was that the Parisian, which had been running her way off from the time when the operations with her engines first began, was still at the time when her engines were set at full speed ahead, in motion through the water at a speed of probably about a knot an hour. The judge makes a lot, as we'll see, of the fact that the Alexandra one was proceeding very slowly to pick up the pilot, or so was the Parisian as the giveaway vessel. And then if we turn to the decision at page 303, because I don't have time, I will ask the court to read this to itself subsequently. At 303 to 304, the Privy Council dismiss the pilotage point that is different because we're picking up pilots, and that disapplies the crossing rule, applying settled authority of the ADA and the SAFA, to which I've already referred. I move on from that. But if I can take the court to page 204, at the bottom, reference is made to Lord St Helier in the Peking, which we've already looked at in the context of the Peking, and the Court of Appeals referenced the Peking. Can I just ask you to pick up, as we come to the bottom of the first paragraph on the top of page 305, what Lord St Helier actually said? The question, therefore, always turns on the reasonable inference we draw as to a vessel's future course from her position at a particular moment, so actual observation. And this greatly depends on the nature of the locality where she is at the moment. And then if I can just say, go down 5 lines, the consideration of the situation must be carried further back to the time when these vessels were approaching towards the spot where the collision took place, and would, if they continued doing, and then these important words, what each of them was respectively doing, and what was the Alexandra one doing? She was allowing herself to be going very, very slowly on a broad east-southeasterly course or heading. Arrive at that spot so as to involve the risk of collision. It's the admission by the majority of the judges of the court below to consider the matter that gives rise to the principal divergence between their opinion and that entertained by their lordships in this case. Mr. Justice Davies, it's to be observed that he speaks of the risk of collision as first arising when the pilot boat was close to the Parisian, whereas when what each vessel was doing for some time before this is taken into consideration, it seems reasonably certain that they were approaching each other. Just apply that test to this case. On crossing courses, apply that test to this case, so as to involve the very risk which resulted in an actual collision. Apply that test to this case. They were in fact converging on a spot, on courses and at speeds, which would probably bring them to that spot so as to present a danger of a collision when they reached it, which each of them would do in the course of her navigation. Now, different vessels are being navigated in different ways. In this case, the Eversmart is being navigated at a smart speed up the channel towards the exit. But the Alexandra one is also being navigated very slowly, dead slow ahead, moving to slow ahead, allowing herself, with the effect of the current and wind, to describe a particular course. The idea the vessel isn't under control, isn't doing anything, or doesn't have a particular course of navigation, in our submission, is fanciful. And when that test, that's the important test in Albana, is applied to the crossing rule, and it can be seen the crossing rule is obviously engaged. It doesn't matter that the giveaway vessel isn't on a definite course. What matters is it's on a heading or a general broad course, which is going to bring about the very situation which Rule 15 refers to. It would be different if the vessel were truly stationary. And we'll come on to this because of the passage in Cockcroft and Lamar, which my Lord Briggs referred to this morning. But if you go over the page, please, at 306, the Privy Council bear in mind why the Parisian tried to say, oh, we were stationary. Again, bottom paragraph, sorry. Again, it might be said that if on their courses and speeds the two vessels would not have arrived at or near the place of collision at or about the same time, and if the Parisian had arrived at and was lying motionless at the place of collision some considerable time before the approach of the Albana, the circumstances might be such as to make the rule, the crossing rule, inapplicable. For then it might perhaps be said that the vessels could not be regarded, and then, my Lord, these words are important, as moving to a spot at the same time, and never could reasonably be regarded as crossing, so as to involve the risk of collision. But such a case which the respondents attempted but failed to make out, and upon which it is not necessary to express an opinion, is far removed from the actual facts of the present case, where the two vessels doing what each of them did were approaching so as to cross each other, or at any rate would probably be in motion and cross each other at or about the same time and place. And that, my lord, is all that needs to be shown. And the stationary case, just for the court to note, in both this passage, it did actually arise and was dealt with by the Court of Session in the case of the devotion to, which isn't in our case, which is in the supplementary authorities, which I'll take the court shortly. So that's the first situation, first requirement for the engagement of Rule 15. Are you crossing? And when one stands back before looking at the facts and asks, were these two vessels crossing? And does it make any difference? The giveaway vessel was doing what she was doing that way. And the answer is no, it can't make any difference. The second element of Rule 15 is they must be crossing so as to involve a risk of collision. And this is the fact that they are moving to the same spot and will arrive there absent any change in navigation to avoid it. At the same time, it gives rise obviously to risk of collision. But the critical factor, not considered by the judge or the Court of Appeal, although the judge relied upon it in dismissing one of the respondents' alternative arguments, is that the risk is to be presumed under the collision rules where two vessels are moving, that's all they need to do, relative to each other, so as to approach each other, and the bearing does not change. And I said I'd take the court back to Rule 7 at this stage. Can I ask the court to turn up wherever they have it, the collision regulations and Rule 7, either in the judgment of the Court of Appeal or attached to the respondent's case or whole in the second authorities bundle. Rule 7 is important because it actually deals with the risk of collision and is headed risk of collision. The general rule that you should be always on the qui-vive to determine if a risk of collision exists. And then Rule D1. In determining if risk of collision exists, the following considerations should be among those taken into account. Such risk should be deemed to exist if the compass bearing of an approaching vessel does not appreciably change. And as the judge found, I can ask you to turn to page 206 of the core volume. As the judge found, in dismissing the respondent's alternative argument, it's at paragraph 66. The alternative argument that the respondents ran below, also ran in the Court of Appeal, was dismissed as hopeless there, that was that you created the risk of the crossing situation, therefore you fall within that special category of case which, if you create a crossing situation, you can't rely upon the benefit of the crossing rules. The judge, in 4 lines down, said the authorities show that a vessel cannot claim the benefit of Rule 15 when the vessel brings about the crossing situation by her own fault. However, Rule 15 applies when vessels are crossing so as to involve a risk of collision. Rule 7D1 provides that risk of collision should be deemed to exist if the compass bearing of an approaching vessel does not appreciably change. The agreed schedule shows that the bearing of Alexandra 1 from Eversmart did not appreciably change. Although Eversmart was not on the starboard side of the channel, it's unlikely the bearing would have appreciably changed had she been on the starboard side of the channel throughout her transit of the channel, because of the direction of width of the channel. So we have here a risk of collision as defined in Rule 7B1. A risk of collision which is as apparent to the Eversmart as it is to the Alexandra 1, because of the crossing situation in which their respective navigations, doing what they are doing, in Sir Dorrell Barnes's words, giving the opinion of the board in the Albano, is unchanged. And in one sense, when one looks at the rules, that really is the end of the debate. The second heading I wanted to deal with was the steady course requirement for the stand-on vessel, because confusion seems to have crept in, particularly in the Court of Appeal's judgment, where the stand-on vessel's requirement, in effect, it has to be mirrored by the give-way vessel's requirement. And it doesn't, because they're not dealing with the same thing. If we have the rules to hand, Rule 17A1, the action by the stand-on vessel, requires her to keep her course and speed. Now, pause there. At least this rule is referring to the word course. Rule 16, the give way vessel, does not refer to the word course. And Rule 17A1 refers to the word course with the verb to keep course and speed. And therefore, the position of the stand-on vessel, the rule itself contemplates that as a matter of language, the stand-on vessel is on a course, and once she's on that course and a crossing situation arises, being the stand-on vessel, she shall keep that course. The position of the stand-on vessel, the nature of the course she must be on, has been considered in the cases, particularly in the Alcoa Rambler. And the importance, I'll just summarise where I'm going, and then I'll take the court to the decision in the Privy Council in the Alcoa Rambler. The importance of the stand-on vessel being on a sufficiently defined course is that that's the only way the give-way vessel will know what she's doing and what she has to do. If the stand-on vessel, or putative stand-on vessel, is on a widely diverging course, which you can't tell what she's going to do next, take the facts in the Alcoa Rambler. The vessel there was on a wide sweeping course, constantly changing heading and direction, large angles. How does the give-way vessel know where she's going to be next? How does the give-way vessel know what to do? How does the give-way vessel know how to react? And in the Alcoa Rambler, that position was considered, where those two vessels were in that sort of situation. The Alcoa Rambler had the Norefjord on her starboard side. The Alcoa Rambler is at page 311 in the authorities bundle, or 312. And the Norefjord, which said that the Alcoa Rambler should have kept out of her way by alleging that the crossing rules apply, was on a curving course, constantly changing curving course, changing heading, direction and course throughout her manoeuvre through a crowded press of shipping in a wartime harbour. And if we go to the speech, or the opinion, I should say, of the board given by Lord Wright, and turn please to page 323. Time is short, so this is a long passage, and I would ask the court to read pages 323 to 325 to itself afterwards. But can I just highlight a number of passages quite quickly? 323. Firstly, Articles 19, second paragraph starting, Articles 19 and 21. Articles 19 and 21 presuppose as their essential conditions that the vessels must be crossing vessels and crossing so as to involve risk of collision. We don't. It is only when these conditions are present that the articles apply, and when they cease to be present, by Lord Hamden's question, the articles cease to apply in the full sense, that is, disregarding for the moment Article 27. But the problem does not depend merely on physical circumstances, as the purposes of Articles 19 and 21 is to impose a duty on the give-way ship to keep clear. That ship must be in a position to appreciate what the situation is and to know what the other ship is doing and whether it is on a course at all, or if so, on what course. In the present case, the Rambler was presented with two alternative possibilities in regard to the Norefjord. And then there was the passage at the bottom, which I took you to, about observation of movement. Over the page, please, to page 324. No, so can I just pick it up at the bottom of 323 because I stopped before I needed to. Lord Wright says, thus there are two questions. Was the Norefjord, remember this is the stand-on vessel, putative stand-on vessel, not the give-way vessel, on a crossing course, i.e. was she on a course at all, and if so, was it a crossing course so as to be likely to involve a risk of collision? Two, was the situation such that the Rambler, the give-way ship, could appreciate what the situation was so as to be able to act as the rule prescribes? It's difficult to define what is meant by course in this connection, and then he refers to the Roanoke, which I took you to. Then if I can just ask you to drop down just after the title in the right-hand side, and the sentence we started, it is only when the give-way vessel is aware or ought to be aware of the fact that the vessels are crossing vessels within Articles 19 and 21, because that awareness is a necessary condition. That this implicitly at least involves that prima facie the alteration of direction is inconsistent with the idea of a course within the meaning of the regulations. Now there he's referring to course as referred to in Rule 17A1. That's why he puts it in quotes. These principles are illustrated by the Albano. The test always was what was being done, open and notorious to a seaman on the other ship in the ordinary course of navigation. The more general question, which has to be considered in this case, whether what the Noraford was doing was being on a course. Again, he puts that in quotes because that's coming course. He puts that in quotes because that's from Rule 17A1, when she was making what the pilot called a curved course. The ordinary idea of a course is a sufficiently constant direction of a ship on the same line or heading. This would enable a navigator, when he sees the other vessel, to know if she's on a crossing course. You can often only become aware of that if you can keep the vessel under observation for sufficient time to ascertain if she is or is not changing her heading. And then he refers to another case, the Kitano Maru. And then if you just come down about 11 lines, after citing that case, Lord Wright says, this case is cited here, the Kitano Maru, as an illustration of the critical test for inferring that the vessel is on course, that her bearing does not alter. It may not often be possible in narrow or congested waters. In the present case, it could not be applied in regard to the Noraford. If it had been possible to watch her movements at some time, the manoeuvre would not have shown that she was keeping a steady course. The heading would have been altering to port. Curved or curving course, constantly changing under a port helm, would not have enabled the give-way vessel to decide how to act for her. So again, this is entirely focusing on, can the give-way vessel respond to the stand-on vessel? Accordingly, of the two conditions, it should be on a course and the give-way vessel should be able to ascertain that neither was fulfilled. It may be that in crowded or congested areas, it may not be possible to ascertain whether the necessary conditions exist. In such cases, Articles 19 and 21 crossing rules cannot apply. So, and this, my Lord, this passage, which is important, both in the context of Issue 1 and in the context of Issue 2, but wherever possible, Articles 19 and 21 ought to be implied and strictly enforced because they tend to secure safe navigation. It is for this reason, and this is important, that the principles laid down in cases like the Velocity and the Echo, also in the Roanoke, have been found to be advantageous. They're the cases that say you don't have it be fixed on a course. You can be doing that and still be a stand-on vessel, because they've enabled a wider scope to be given to the crossing rule, even in cases where, in a strict sense, there is a deviation from the ship's course. And that passage was entirely lost sight of by Mr. Justice Tier in the Court of Appeal in saying that Rule 9A and Rule 17A1 can lead to completely conflicting obligations. They can't. And that's the reason they don't. So that is in relation to the stand-on vessel. Why, then, is it said to be implicit in the obligation of the give-way vessel that the give-way vessel must also be on a sufficiently defined course? And test it at stages. 1, does Rule 15 require it to be on a sufficiently defined course? No, it only requires it to be crossing. What requires the stand-on vessel to be on a sufficiently defined course? Rule 17A1 says so, as interpreted by the courts in the Alcoa Rambler. Otherwise, the give-way vessel can't do what she's got to do. Does Rule 16 carry with it the necessary implication that the give-way vessel must be on a sufficiently defined course? No. Why? The give-way vessel only has to know what the other vessel is doing, which is approaching on her starboard side. She only has to know that if she keeps doing what she's doing, drifting to the tide, drifting to the wind, proceeding at 1.5 to 2 knots on an east-southeasterly broad heading, they will cross and they will collide or come into close quarters. The give-way vessel doesn't need to be on a definite course to enable her to do anything. She just needs to know that she's being navigated in a particular way that is going to bring about a crossing situation falling within Rule 15. Does the stand-on vessel need the give-way vessel to be on a sufficiently defined course to do what it's doing? No, for 3 reasons. The stand-on vessel does not need the give-way vessel to be on a sufficiently defined course to be able to appreciate that the way in which the give-way vessel is being navigated is to make her a crossing vessel and to give rise to a risk of collision. Take the facts of the Taunton and reverse them. Assume the stand-on vessel is coming up ahead of her on her port side is the fishing ketch in the Taunton. The fishing ketch is making for Cardiff. She's finding a very hard effort. because she's constantly being ported by this very strong ebb tide. She's trying to get round over and over again, but she's being ported. So the course is very irregular, but she's heading in a broad northwesterly direction for Cardiff. Why does the stand-on vessel not instantly appreciate that if that course is continued, or that broad course is continued, they're going to cross and they're going to be at risk of collision? She then stands onto that vessel because she appreciates that that vessel will know that she's standing on and that she will have to give way to it. Otherwise, you've got Lord Justice Farwell's situation of her having to give way to a vessel which is crossing ahead of her on her port side, which is an anathema in the context of the rules. Secondly, the stand-on vessel does not require the give-way vessel to be on a sufficiently defined course to enable her to execute her obligations. As Lord Wright explained, the give-way vessel can't exercise her obligations under Rule 16 to give way unless the stand-on vessel is on a sufficiently defined course. Non sequitur the other way around, because the stand-on vessel only needs the give-way vessel to stop what she's doing. To help her stop what she's doing, she stands on. She keeps her course and speed and relies upon the give-way vessel taking early, prompt, substantial action to get out of her way. She doesn't require the give-way vessel to be on a sufficiently defined course to perform her obligations. And thirdly, the stand-on vessel does not require the give-way vessel to be on a sufficiently defined course in order to comply with her subsidiary Rule 17 obligations. The Court of Appeal, which we'll see in a moment, said the stand-on vessel might be embarrassed in dealing with her subsidiary obligations. The subsidiary obligations which the Court of Appeal had in mind were Rule 17A2, which is, as it were, the last-ditch situation. The stand-on vessel keeps standing on. Right at the last moment, it becomes apparent that the give-way vessel is not going to give way. What would have happened in any other sort of crossing situation. She then has to take action herself. And that's been described as the ticklish moment when, how late do you leave it? Is she suddenly going to give way at the last minute? In which case, if you do something dramatic, you will have caused the collision. Always difficult. But she doesn't need the give-way vessel to be on a sufficiently defined course, because by that stage, the give-way vessel shouldn't be there. The give-way vessel is only required to stop what she's doing. Similarly, the subsidiary obligation in Rule 17B, when the stand-on vessel required to keep her course and speed finds herself so close, the collision cannot be avoided by the action of the give-way vessel, she shall take such action. But again, she doesn't need the give-way vessel to be on a sufficiently defined course at all. And the Court of Appeal, in great respect, seriously misunderstood how those rules actually work. So again, pausing there, looking at Rule 15 and looking at Rule 16 and 17, there is no requirement and no basis for a requirement that the give-way vessel needs to be on a sufficiently defined course in the same way that the stand-on vessel needs to. Authority is my third topic, and there are four cases I want to take the court to. I have to do it quite quickly. The Albano we've already looked at. The Parisian going very slow, give-way vessel. She was still a give-way vessel. She'd taken all way off and was effectively doing 1 knot and had been for some time. The Broomfield, which is in the authorities bundle, please, at page 356. The Broomfield is an important case because this is a drifting vessel case. And the facts were effectively that the Broomfield was a steamer coming up on the starboard side of a fishing trawler, Lucania. Lucania was waiting for the tide and had put her starboard helm round and had allowed herself to drift. She was not underway, so she had no way on. Be careful about the term underway, given it's a defined term in the regulations. She had no way on, but she had no steam on, but she was drifting. She was not stationary. Yes, my lord.
She was underway, but she didn't have way on, as I understand it.
She was underway, yes. And she had some way on.
Oh, okay.
As we'll see. Because you can be stationary and underway because you're not anchored. That's a rather odd definition of underway in the rule. But she was underway because she wasn't anchored, and she did have way on because she was at the whim of the wind. And where the wind listeth, there also went the Lucania. And if you come on then to page 357 and the second column, Mr. Aspinall, KC, and Lewis Node, the respondents, the Lucania, said that she was stationary. The president. So this is a decision of Sir Gorrell Barnes as the president of the Probate Admiralty and Divorce Division, and Sir Mr. Justice Bargrave Dean, the Admiralty Judge. So two powerhouses in one case. The trawler appears to have been lying with her head more or less to the north off Bull Point, so doing this effectively, and had her navigation lights up. It said that her helm was lashed a starboard and she was waiting for the tide. The Broomfield was bound down the Bristol Channel. And then I don't think I need to deal with the rest until we come down to about 10 lines up. The question then arises, what are the true facts? And when they are found, what rules apply? I think, and the elder brethren agree in this view, on the nature of the accident, the vessels must have been slightly crossing. It is an absolute unintelligible and almost absurd point to suggest that the Broomfield was coming down channel with the Lucania's green light showing on the Broomfield starboard side, and that she being bound down channel would have any reason or desire to port and run into the Lucania. Therefore, I think that set of facts is not, I think, the true view to take. The true view is the vessels were slightly crossing and the Lucania was being helped forward by the southwest wind which prevailed, which produced a certain amount of crossing on her part. I pause there. She's on a broad course. She's not following a nice, sufficiently defined course because she's literally at the mercy of the southwest wind taking it as it goes. When the facts are found in that way, you have a case of two steamers crossing. And the only question that becomes necessary to consider is whether Article 19 applies. It is said the trawler was not bound to keep out of the way because she was more or less stationary. And the case of the Helvetia is cited in support of that proposition. And then the Helvetia is distinguished because the Helvetia, I think, had her fires drawn or some abstruse phrase. So we have, in the Broomfield, we have a vessel which is underway and with some way on. Contrast our case, where we've actually got the vessel going dead slow ahead, 1.5 to 2 knots with engine orders. Here, she had her rudder lashed to starboard helm, and she was just about to drift, but was drifting slowly and caused a crossing situation. Held, Rule 15 engaged, and quite right too. Cockcroft and Lemaire's book, in the extract that my Lord Briggs took me to this morning, refers to the Broomfield, and I asked the court to turn, and this was a reference which did go wrong this morning, to page 942. Mr. Jacobs can work out the correct reference.
I've got it.
This is Cockcroft, yeah.
This is Cockcroft and Lemaire.
So, could you take us to the internal page number of Cockcroft?
The internal page number of Cockcroft, my lord, is page 77.
Thank you. Maybe page 942.
It's 942 in the bundle, and page 77.
945 in mine, I'm afraid.
Right. Okay. Well, if we're in the, if we have managed to get there, it's page 77 of the internal numbering, and this is under the heading Rule 15 crossing situation. So this is where they deal with a vessel lying stopped, and this is very important because this deals with a vessel which is lying stopped, which is not stationary but which is underway. I think the editors or authors here are using underway to mean with way on, and or possibly not. But she has still she's still in a crossing situation. She's still a give way unless she is stationary. So vessel lying stopped, and because it's stopped doesn't mean it's stationary, as we've seen from the Broomfield. A power-driven vessel which is underway but stopped must, unless she is not under command or restricted in her ability to move, keep out of the way of another vessel which approaches her so as to involve the risk of collision from any direction between right ahead and 22.5 degrees abaft the beam on her starboard side. Because from 22.5 degrees abaft the beam, it's an overtaking situation with stern light showing. So remember that the approaching ship must not be expected to take avoiding action. And then they refer to the case of the Lucania and the Broomfield at the bottom, with engine stop waiting for the tide, was alone to blame for failing to take steps to avoid a collision with a power-driven vessel approaching from her starboard side. So if one considers how the textbooks and the practical guides have dealt with it since 1965, Cockcroft and Lemaire, citing the Broomfield, even if you're stopped but not an anchor, you can't presume upon the vessel that is approaching you from your starboard side that she has to get out of your way. The only situation where that would apply was if you are completely stationary. Very rare the case.
Why?
Well, my lord, because of the reasons given by Lord Wiley in the devotion too. And I, in one sense, I am happy for the court to say that if you are underway and stopped and stationary, you must still give way.
Yeah.
That's an a fortiori case for me, and I'm extremely happy to accept it. But there is a decision, which we found in our researches for preparation for oral argument, of the Court of Session, Lord Wiley, which considers this very point, the devotion 2, which is in the supplementary authorities bundle at tab 4, page 26. And the facts were these. 2 trawlers out sprat fishing in pairs. The Mayflower stopped, and apparently on the facts was entirely stationary. Slightly difficult to believe, but those are the facts, which was common ground. She was stationary. The Devotion was approaching her at speed and was the putative stand-on vessel coming up on her starboard side. And then Lord Wiley's decision is summarised in the headnote at column 2 on page 26. As a matter of construction, Mayflower was not a give-way vessel in terms of Rule 19, in that the words underway in the collision regulation rules meant a vessel which was making way through the water and did not cover the position of a vessel lying stationary at sea. Now that is in one sense debatable, highly debatable, because both vessels were on a converging course. One vessel was selected as the give-way vessel and the other as the stand-on vessel. But the situation with a stopped vessel was very different, and in conditions of good visibility such as here, no special provisions were called for. Now, if we then go on to the argument, we need to pick it up at the bottom of page 27, column 2. The defendant's primary contention is the Mayflower is a give-way vessel in terms of Rule 19. And this, of course, is a fundamental and well-recognised rule. But the speciality in the present case, which was argued precluded the application of the rule, was the fact that the Mayflower was not making way at the material time. Counsel for the pursuers referred me to a number of decisions where both vessels were making way, Peking, the Alcoa Rambler, and then we can skip to the bottom of page 28, column 2. The words underway, which appear in the rules, would normally connote, I would consider, a vessel which was making way through the water. Except where the context otherwise requires, these words are, however, defined in terms of Rule 1C5 as a vessel is underway when she is not at anchor or made fast to the shore or aground. In other words, when she's not fixed, she's underway. Mr. Bruce, the defenders, advanced the contention that rules place vessels into 2 categories, those which were underway and those which were secured in terms of definition. He argued if a distinction was to be drawn between underway and making way, the rules did not cover the position of a vessel which was lying stationary at sea. I agree that in the event Rule 19 would not, in that event, Rule 19 would not apply. I agree also with his contention that looking at the matter from a practical point of view, at first sighting a stationary vessel would present the same aspect as one which was making through the water. Indeed, if she was proceeding at minimum speed, the distinction with a vessel which was stationary could be an exceedingly fine one. It was for reasons such as these, it was argued, that the rule failed to be applied in the case in which the risk of collision arose where one vessel was stationary, as well as in the usual case in which both vessels are making way through the water. Read literally, I find it difficult to construe the words, and this may be a way of getting at it through Rule 15, my Lord Lord Briggs. When two power-driven vessels are crossing so as to involve the risk of collision as meaning anything other than where two vessels are each pursuing courses which, if maintained, involve the risk of collision. A course is not simply a heading, as Mr. Bruce suggested. It involves the concept of progress or passage, my Lord, simply motion, as we saw in the other case. And indeed, I note that the shorter Oxford Dictionary includes in the definition the direction in which a ship sails. Support for this view is to be found in Marsden, and then that's two vessels end on, etc., derived from the Peking, which I have to skip over. And then this, it is precisely because both vessels are on converging courses that the rule selects one of them as the give-way vessel and the other as the stand-on vessel. Note there that he's using the word course in the very broad sense that he's just taken from the Oxford Dictionary. In my view, the situation with a stopped vessel is entirely different. It is to be noted that in Rule 15C, which relates to conditions of restricted visibility, there's provision in paragraph 2 that a power-driven vessel underway but stopped and making no way through the water shall make certain sound signals. The bearing of the stopped vessel can only be dead ahead if the oncoming vessel is on a collision course. And he talks about that. I've accordingly come to the view that as a matter of construction, Mayflower was not a give-way vessel in terms of Rule 19, and that apart from the ordinary law of negligence, provision must be found elsewhere. Now, what Lord Wiley appears to be saying is that giving course its broad meaning, inherent in the concept of crossing in Rule 15, you've both got to be moving. You can't have one vessel which is stationary and one vessel which is moving towards it. That's not a crossing situation. Again, that is debatable, and the a fortiori position is very acceptable to me. But even if the vessel simply has to be moving, on any view, the navigation of the Alexandra 1 satisfies any movement criteria. She's dead slow ahead on an east-southeasterly heading or course broadly defined, on a crossing course, and being navigated deliberately in that way. Why is she not a give-way vessel? Why does it make any difference that she's not on a sufficiently defined course, but she's on a broad east-southeasterly course? The situation arrived at by the judge and the Court of Appeal is productive of high danger in our submission with the disregard of the crossing situation. Even if the devotion to is wrong, it demonstrates why the argument of the respondents that the crossing rules don't apply to this moving vessel under steam being navigated must certainly be wrong. The last author, my Lord of Boroughs.
Just so I'm absolutely clear, as I understand it, you would accept that the Alexandra was not on a sufficiently defined course, but your proposition is that the give-way vessel, putative give-way vessel, does not need to be on a sufficiently defined course, because provided the vessel, the give-way vessel, is not stationary, then the give-way rules, in other words, the crossing rules apply. Is that correct? So you could accept, or are you accepting, that the Alexandra was not on a sufficiently defined course?
Well, I have a finding of the judge that she was not on a sufficiently defined course, and the rejection of an argument by Mr. Jacobs that that was wrong by the Court of Appeal against me in trying to reopen the sufficiently defined course. But what I would say is that the word course is not found in Rule 15 or Rule 16. If you're building the word course in, there is no need to build in the same meaning
No, I understand
in Rule 17A1. But what is strange, what is very strange, is if one reversed this situation again, it would be very odd to say that the Alexandra 1 was a stand-on vessel. It would be very odd to say, when you consider cases like the Taunton, and particularly the Taunton, where the vessel's doing this, it would be very, very odd to say that the Alexandra 1 wasn't on a sufficiently defined course, because you could see what she was doing. She was going broad east-southeast to the mouth of the channel to pick up a pilot.
But nevertheless, your proposition is that even that one is prepared to assume that the first instance judge and the Court of Appeal have ended that issue, and that you are making a proposition in any event by which your side would succeed. Is that right?
Yeah,
That's correct, my lord.
yeah.
Now, I've got about 4 minutes left, so I'll deal very quickly with the avance, which is the authorities bundle, please, at page 148. The avance it was relied upon by the Court of Appeal. 148, sorry, 348, sorry, wrong reference. And I'll just take this very quickly. The judge at page 351 rejects the application of the crossing rules to the Bambara. He cited, as you see at the bottom of page 351, column 1 going up to column 2, the avance as the Alcoa Rambler, which is the stand-on vessel case. In our submission, that it was wrong to do that. But you need, in considering the facts, which you'll have to go back and look at, of the avance and the Bambara, to bear in mind the Bambara had been stationary. Only 3 minutes before the collision, she kicked her engines on and moved forward a little bit, 2 cables, I think, at a very slow speed. So in those circumstances, which the judge found inexplicable, in those circumstances, the avance doesn't really grapple with the sort of facts we're dealing with a long, steady progression east-south-east. But if that is an application of the Alcoa Rambler to the giveaway vessel, in our submission, it is wrong as a matter of principle. And it makes no difference. It was a decision of Mr. Justice Brandon. It is wrong. But in our submission, it's really a case very much on its facts, as you see. The facts are really very singular. The other cases relied upon are the Orduna and the Savina being the last case before this one in the House of Lords in 1976. They did not have to consider the situations we're dealing with at all. So as a matter of authority, they are unhelpful. They refer to vessels being on courses, but that depends what you mean by courses. And as I say, I don't have time to take you to the preliminary act, the collision statement of the case by these respondents. They described themselves, when they were pleading their own case, as being on an east-south-easterly course to pick up a pilot at 1 knot. That's what they were doing. The navigation, fourthly, the navigation of the Alexandra one, and I've already covered that in detail in dealing with this U1. But in our submission, she was plainly moving. She was under power, dead slow ahead. She was doing 1.5 to 2 knots. Her course changed a little bit from time to time, but that was because she was going at such a slow speed, so she kept falling off a little bit. But in our submission, that doesn't alter the fact that she was on a crossing course, latu sensu, rather than strictu sensu, and that's all it needs to be for the purposes of the crossing rule. Lastly, let me deal with the decisions below. Mr. Justice Tier simply analysed the facts and said no sufficiently defined course. There is no analysis, and to be fair to the judge, as I've said, he wasn't really addressed with any argument on what the principles were and why it wouldn't apply. The Court of Appeal have 2 strands to their decision: authority, particularly the avance. In our submission, that's no substitute for actually looking at all of the cases. They were unassisted by the Albano. We don't know why, because the Albano is a very clear case, very similar, of a crossing situation happening at very slow speed. And principally for the Court of Appeal, they considered that a give-way vessel had to be on a sufficiently defined course to allow the stand-on vessel to do what she had to do, and I've explained why that is wrong as a matter of principle, and to allow the give-way vessel to identify that she is a give-way vessel. The stand-on vessel to identify that she was a give-way vessel. And again, I've explained why that is wrong. Just take the example, which I'll end with, of the Broomfield. A fishing smack, not under power, unlike this vessel, just drifting to the wind on a very slight crossing course, possibly not going very fast, moving a little bit as the southwest wind took her. And in those circumstances, the crossing situation was plainly engaged. On what basis, what principled basis can it be said that a crossing situation is not engaged when by choice, the Alexandra one navigates herself across the path of a vessel approaching on her starboard side at speed and expects her to get out of the way and for her to be unimpeded in her manoeuvre? In our submission, the decisions below are wrong in principle and simply failed to address the true principles which apply to the crossing rules and the respective interaction of the 2 obligations on the giveaway vessel and the stand-on vessel. And the decision is, in our submission, productive of considerable uncertainty and danger, because, again, and I end on this, the crossing rules have been stressed as being the best way in this most common situation of avoiding risk of collision and close quarter situations which make people have to react quickly and get it wrong. This is Justice Sheen in the Maluja number 2. For those reasons, we submit that the appeal should be allowed on both grounds. And unless I can help the court further, having overrun, I do apologise by 2 minutes. Those are the submissions on the behalf of the appellants.
Thank you, Mr. Rennie. I don't think there are any further questions at this stage.
Thank you.
We're grateful. Thank you. We'll adjourn for 2 minutes, and then Ms. Silverratnam can begin and show us the video. We'll give the technical team a moment just to set that in place. This is the resumed hearing of the appeal in Evergreen Marine against Nautical Challenge. We're now going to hear the submissions of Silverratnam on behalf of the respondents.
May it please the court. I'd like to begin by showing you the chart, which I hope you have in paper copy. It's British Admiralty chart 3739. And I just wanted to show you some key features on it. The channel with which we are concerned is marked by lateral buoys. Buoys number 1 marking the seaward end of the channel. And at the seaward end, we have a designated pilot boarding area, which is designated by this circle that we see here.
Yes.
That circular area is about 1 nautical mile in radius, and the limit of that circular area is about 3 cables beyond buoy number 1. The collision itself, as found by the learned judge, was 5 cables west-northwest of the number 1 buoys. So it was just outside the dredge channel, but within the pilot boarding area. And you will have seen from the acetate overlays the plots that have been agreed and which can be overlaid on the chart to show exactly where the collision occurred. Now, the pilot boarding area was a feature which is of central relevance in this case, as noted by the Court of Appeal in its judgment at paragraph 59. And the fact that the narrow channel had its entrance and exit in that pilot boarding area is highly relevant to what would be safe navigation of both ships encountering each other in that vicinity. As the Court of Appeal noted in paragraph 77 of its judgment, page 168 of your core bundle, had the crossing rules applied, there might well have been concern about the prospect of the Eversmart maintaining course and speed as it exited the narrow channel through the pilot boarding area at full speed. Now, we know that the Alexandra 1, on the facts as found by the judge, was waiting to board a pilot. And we also have important findings of fact about Eversmart's knowledge of what the Alexandra 1 was doing. We can pick this up in various points in the judgment of Mr. Justice Tier. At paragraph 111 of the judgment, which is in the first core bundle at page 176, beg pardon, I've given you the wrong reference there. It's actually at page 219 of the core bundle. The judge finds, this is about 5 lines down, that it was known that Alexandra 1 was outside the channel preparing to enter it, and that the vessels might meet either in the channel or in the approaches to it beyond the number 1 buoys. That will have some significance when we come to consider my learned friend's submission about whether shaping to enter the channel makes all the difference about how you treat this encounter. Mr. Justice Tier also made the point in paragraph 70 of the judgment. This is at page 207 of the bundle, and this is the last couple of lines of paragraph 70, that it would have been apparent that the Alexandra 1 had moved less than a mile from C-21, and it would or ought to have been obvious that she was waiting to embark a pilot. Likewise, we know from what Mr. Justice Tier finds as a matter of fact that the pilot on the Eversmart had warned the Eversmart's master at C-9 that the tanker Alexandra 1 was to port and to take care. The judge also finds at paragraph 74 of the judgment at page 208 that the Eversmart was or ought to have been aware that the Alexandra 1 was proceeding towards the channel, intending to embark the pilot and then proceed down the channel. And the Court of Appeal likewise note the concession made in the Eversmart's skeleton for trial, which it called a realistic concession, that the Eversmart knew that the Alexandra 1 was waiting to enter the channel. You've also been shown very recently what the Court of Appeal said in paragraph 60 at page 163, that at all material times Alexandra 1 was in the pilot boarding area and she was there to state the obvious with a view to embarking a pilot and entering the narrow channel. That was the only reasonable inference. So at this point, I could perhaps ask Mr. Sheck to display the start screenshot of the video, and then I'll make some comments before we begin playing. Now, before we begin to play this video, let me explain how it was prepared. It was prepared in-house by those instructing me, Clyde & Co., using the radar and audio data which had been downloaded from the VDR of the Eversmart. Now, this is exactly the same data upon which the agreed plot of the collision was prepared in our core bundle at pages 168 and 169. And it plays in real time. And I would ask the court at its leisure to actually play the whole thing through without interruption, listening to the audio, which also accompanies it. The audio is in our core bundle, starting at page 142 and running through to page 245. Now, the radar image that you see on the screen is exactly the same as that which would have been seen by those on the bridge of the Eversmart had they been looking at the radar. The radar image changes every 15 seconds. The chart shown on the screen, left-hand side, is a computer scan of the relevant section of the British Admiralty chart, C3739, that we looked at a few moments ago. And scale representations of each ship were created in-house by Clyde & Co. The positions of each vessel have been taken from their respective VDR data, and they were then plotted, and computer software was used to interpolate the track of the vessels between the plotted positions. And they reflect exactly the agreed plot which has been produced in the bundle and the agreed acetate overlays. For convenience, each ship has been drawn to scale, and the arc of visibility of the port and starboard light segments have been drawn on. As I mentioned, the video also contains the audio downloaded from the VDR of the Eversmart, and the audio is reflected in the agreed transcript, which we have in the core bundle at pages 142 to 160. And the video can be played with or without sound, and the audio is continuous. Now, turning back to the radar image on the screen, and it may help at this point if you can turn to a supplementary core volume, which I hope has been lodged in hard copy with all of you, because tab 1 of that bundle shows you a photograph of what you're going to be seeing when I pause the video. So the radar image that you can see, which is page 3 in our bundle, corresponding to what is on the screen right now, it records at the top the usual information you would expect to see on the radar. It's got the heading, that's HDG, the course over the ground, COG, which is just to the right of that, and speed over the ground, SOG. Now, there's also a facility.
So, forgive me for interrupting.
Yes.
I'm afraid we don't have hard copies of the supplementary bundle, but we do have it electronically.
Very good. If you have it electronically, it's going to be the supplementary core volume at page 3.
Let's just see if we can find that.
Thank you.
No, I'm afraid I don't have that.
We can make sure that it's lodged tomorrow morning so that you have it for reference. And I can just speak into the transcript, the page number, so that when you come back, you can find the correlation.
Thank you very much.
If you go to the screen again, below speed over the ground, you can see that there is a reference to EBL and VRM in the box beneath. EBL refers to electronic bearing line and VRM to variable range marker. And EBL and VRM are used to acquire or select targets and determine whether a risk of collision exists. And these are standard tools which are used to measure the distance and bearing of your own ship to a target object. Now, as you can see, the EBL and VRM are off. This facility wasn't used by those on board the Eversmart to acquire targets at any relevant time prior to the collision. Now, the radar also shows Eversmart's position by latitude and longitude, and it gives you a time in UTC. I'm looking now towards the bottom right of the screen. Now, the UTC time is 4 hours behind local time. And to make it easier to correlate with the times given in the judgment and also in the movement schedule, which is in the core bundle, I'm going to give the times by reference to local time, but bear in mind it's 4 hours in advance of what's shown as UTC. Now, you've got some pairs of small lights that can be seen running from the bottom of this screen towards the middle of the screen, and they are the channel marker buoys, which we could see on the paper chart. And when the video starts, which is at the time 23:32:22 local time, which is this first screenshot, we are 10 minutes before the collision, or C-10. And at this point, Eversmart is passing the number 3 buoys, and the pilot boat, which is shown as a green triangle 79, which you may just be able to see towards the bottom half of the screen, is alongside her. Now, we can see that her speed over the ground is 12.6 knots. Her course over the ground is 313 degrees. And she's heading 316.4. Now, that indicates that she's crabbing up the channel and is being set to port under the influence of the current and or the wind. We can see a number of echoes on the radar screen, and the Alexandra 1 is the large echo, which is to the north-northwest of the number 1 buoys, just below the cross. I hope you can see the cross on the image. So you can see then a large echo below that, which is the Alexandra 1. Now, the two echoes which are to the left of and behind the Alexandra one are the Zakir Bravo and the barge that she was towing. And you'll be aware that the audio shows that the Zakir Bravo and the barge had a conversation with port control, which was misunderstood by those on the Alexandra one, but that's where those two vessels are. Now, as I mentioned earlier, the green triangle marked 79 is the pilot boat. And as we start to play the video, you will shortly see that that green triangle turns red and a CPA proximity alarm flashes in red when the pilot boat is about 100 feet from the Ever Smart. So I'm now going to ask Mr. Sheck to start the video without the audio and to pause it at 23:32:52 local time. And to play without audio, please. Thank you. Now we've come to the pause point, which is at 23:32:52, and this is at C minus 9.5. And we can see that the green triangle has turned red and that the CPA, TCPA proximity alarm has triggered due to the proximity of the pilot boat. If we can resume playing and pause at 23:33:22, please. Thank you. Now we've reached C minus 9, and when you come to look at your radar stills, it's page 5 of the supplementary call bundle. Now this is the point in time at which the pilot on the Ever Smart warns the Ever Smart's master of the fact that Alexandra 1 is to port and to take care, and one can see that on the audio record at page 149 of the call bundle. Now, Ever Smart is now on the port side of the channel, and she remains on the port side until collision. And that's apparent from the findings of the judge and also the agreed schedule of movements. I'll now ask Mr. Sheck to continue playing and to pause at 23:34:22. Thank you. We're now at C minus 8, and this correlates to page 6 of the supplementary bundle. Now, Ever Smart's radar is now switched to north up, and it was previously head up. I'm now going to ask Mr. Sheck to continue playing and to pause at 23:35:07. Thank you. Now we're now approaching C-7, and we can see that a red triangle has now illuminated on the pilot boat, and there is a warning bow cross that's appeared on the screen due to the proximity of the pilot boat. And we'll see as we continue playing that the pilot boat, as it proceeds towards Alexandra 1, assumes a green triangle mode once more. For your note, this radar still appears at page 7 of the supplementary bundle. If you could now play and pause again at 23:36:22, please. Thank you. We're now at C-6, page 8 of the supplementary bundle. We now have Eversmart passing. We've gone slightly further. C-6, we have Eversmart passing number 2 buoy at a speed of 9.9 knots. I think we've gone a little too far with the video. The pilot boat is proceeding towards Alexandra 1 at C-6. At 23:37:52, if we could advance the video till then and pause, I can make some further observations. Thank you. Again, I think this is slightly ahead of the still that we have, but we're now C-4.5 or thereabouts, page 9 of the supplementary bundle. The Eversmart's speed, as we can see on the radar, has now increased to 9.9 knots, and her speed is increasing continuously from this point on. If I can ask you to play to 23:38:22, which I think is where you're on at the moment. That is C-4, and we see that her speed has increased. Then if you could play again, please, and pause at 23:39:37. think this is the point here. So we are now approaching C minus 2.5, and it correlates to page 11 of the supplementary bundle. The pilot boat is passing ahead of the Eversmart, and we can see the Eversmart speed is now 10.7 knots. And again, it continues to increase from this point on, as we've seen it increasing before. If you could continue playing and pause it at 23:39:52, so very shortly after you've started again. Thank you. So we're now at C minus 2.5, at page 12 of the supplementary bundle. Eversmart's speed is 10.9 knots as she's approaching the number 1 buoys. Alexandra 1 at this point is 7 cables from the number 1 buoys. If we can now resume playing and pause at 23:40:22, please. Thank you. We now have Eversmart passing the number 1 buoys at a speed of 11.3 knots, and this correlates to page 13 of the supplementary bundle. I could now ask for the video to be played and paused at 23:41:22. Thank you. We're now at C minus 1.5, page 14 of the supplementary bundle. The pilot boat is on the port side of the Alexandra 1. Eversmart's speed has increased to 11.8 knots. The pilot boat's proceeding around the stern of the Alexandra 1 so as to approach her from the starboard side where her pilot ladder is rigged. And when you come to play the video with audio, which we'll do after I've reached the collision point, you can hear some frantic instructions to the Eversmart from the pilot, from the Alexandra 1, and also from port control to go hard to starboard. If I could now ask for the video to be played and paused at 23:42:22, which is the moment of collision. Thank you. We are now at C minus 0, the point of collision, which we can tell is in the pilot boarding area, and it will correlate with page 15 of the supplementary bundle. Eversmart's speed is shown on the screen as 12.5 knots. Now, at this time, the red warning sign, CPA, TCPA, has flashed due to the proximity of the pilot boat, not the Alexandra 1. That's because the Alexandra 1 was never acquired as a target by the Eversmart. When the pilot boat moves out of range, the red warning sign disappears. I could now ask Mr. Sheck to play with the audio from 45 seconds before the collision to the collision uninterrupted. And the court will be able to follow the audio using the typed narrative at pages 154 to 155 of the bundle.
Yes, if you like more, there is not. Morning.
Thank you. The court hopefully heard the master of the Eversmart saying, "What's that?" at 3 seconds before collision. And when you go on to look at the full audio transcript, you will see that at 23:44 on page 157, the master talks to himself and says, "How come you didn't see it?" And then at 23:48 on page 243 of the audio transcript, he says, "We now stop here. Yes, now we stop here. Is it serious? I think it should be pretty serious. We hit her because she stopped outside waiting. We were leaving the port. We did not see that. I saw the light, but I didn't know she was transverse. So we knock against her bow." That may be a convenient point unless the court would like to ask any questions arising out of the video.
Oh, thank you very much, Ms. Selvaratnam. We'll leave it there for this afternoon, and we will resume tomorrow morning, please, at 10:30.
Thank you.
Thank you all very much.